right. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right. Good morning. Welcome to the Fourth Circuit. Even though we're by video today, we're glad to have you, and we'll hear argument in our first case, United States versus Franklin. Ms. Haygood.
Sandra Haygood for the appellant, Mr. Franklin. May it please this honorable court. In this case, the parties agree that because the enhancement under 2B of the guidelines for possession of a firearm in connection with the offense does not include definitions or commentary and has not generated any published cases in this circuit, the enhancement must be applied by turning to other provisions in the guidelines which use the same language. Thus, the parties agree that the enhancement in 2B should be interpreted the same way as the enhancement under 2K, which applies if the defendant, quote, possessed any firearm in connection with another felony offense, end quote, and includes commentary defining in connection with, and has generated extensive case law in this circuit.
In this case, it's, I think the actual guideline for this offense is possession in connection with the offense as opposed to another offense.
That's exactly right, Your Honor. That is a key distinction. And in this case, it's very significant because in this case, it means that the enhancement should only apply if the firearm was possessed in connection with either stealing or possessing the checks, instead of it can't have to do instead with the drugs that were present in the car. Thus, the parties agree that this enhancement should be applied in relation to the way 2K works, except for that distinction that you have pointed out, Your Honor. This phrase "in connection with" has a settled...
You agree, Counsel, we're here on plain error review, so
yes.
This is not as if there were evidence or some objection raised in the lower court.
Yes, Your Honor, and that's exactly why I'm starting where I'm starting, because I want to make it clear that there was plain error. The government doesn't argue that there could not have been plain error. The government argues that the district court did not plainly err because the government argues that the district court correctly applied the enhancement, but they don't argue that the government could not have plainly erred. So we do have to overcome that, but we can overcome it because there are decades of cases applying that language "in connection with" in this circuit, and the district court plainly erred by not applying that case law. Furthermore,
Why don't you explain to us why, in your view, there is an error under the case law?
Okay, yes, Your Honor. Well, first of all, under Mitchell and Bolden, the district court plainly erred because under Mitchell and Bolden, to apply the enhancement for possessing a weapon in connection with the offense, the court is required to make a finding of facilitation, number one, and that finding of facilitation has to be supported by reference to specific facts of the case, and the district court didn't do either one of those things here. Facilitation.
And if there had been objections to that, that your argument would be spot on, but there was no objection, there was no evidence entered, so how can we make a determination as if there were?
Your Honor, that is a good question, but despite the fact that there wasn't an objection, that doesn't free the court from its obligation to correctly apply the law. And the district court was still under an obligation to correctly apply the sentencing guidelines. And in this particular case, that means because of the decades of precedent in this court applying the language in connection with. This court was under an obligation to correctly apply the law, which meant correctly applying the language in connection with, and the district court didn't do that. It does, you know,
I don't think anybody argues that there's no finding here. I mean, we all know why, because nobody objected or didn't offer any evidence. So you seem to be arguing there's under plain error where the burden is yours, that the district court was under some sort of sua sponte duty to come in and make these findings on its own.
Well, I'm just arguing that I think the case law does say that the district court had an obligation to do that. And I do think that the precedents establish that. But even if we want to give the district court on making that initial finding on finding a facilitation, the district court didn't cite to any facts. The PSR didn't cite to any facts. The government in its arguments at sentencing didn't cite to any facts. There were no facts in the record that would have supported this application of this enhancement under the guidelines. So it is true that
Well,
we have.
it's arguable. I mean, we're never going to know because the arguments weren't made. But if the evidence were that the defendant was stopped and he had a gun and he had some cash and he had some weed and he had a check, it'd be pretty hard to make that argument. But I don't think you can elide that there were $750,000 of stolen checks in the trunk. And there's a lot of people out there on the street who would think $750,000 is something they want to take steps to protect.
Well, that's true, Your Honor, but I think it's extremely significant in this case that there was absolutely no evidence that Mr. Franklin was selling the checks. And if we think about the way that this enhancement can work when we're talking about selling drugs, it's the reason that there's such a close association.
Well, I mean, do you think he was going to use them to decorate his wall? Or, I mean, he's obviously stolen them for a purpose.
Yes, he's clearly
Logically, you would think that was for some sort of monetary remuneration.
Yes.
And even if he disposed of them at 10 cents on the dollar, that's probably worth more than everything else that was in the car.
That's absolutely true. That's absolutely true. But the point about selling the checks, first of all, there's no evidence that he was going to sell the checks. The other ways that he could make money from having the checks is by trying to pass them fraudulently, which is exactly the only time that he did actually get any financial benefit from the checks was that he himself cashed a check at a Walmart, and that's the way that he got money out of it. So there are ways to get money from stealing the checks without actually selling them. And there was no evidence that he tried to sell them. He didn't need a gun to go into a Walmart and pass the check off as being made out to him. He didn't need a gun to do that. The way that he might have needed a gun potentially is if he were engaged in selling the checks, then he has this contraband and people who might buy it from him know that he has it. That's why there's such a close correlation between guns and violence and trafficking drugs, because if you're selling drugs, the people that you're offering them for sale to know that you have the drugs and they know that you have cash, and they're not honorable people, so they're probably going to be, there's a big chance that they're going to try to steal them from you. But here, there was no evidence that he was trying to sell the checks, which means that there was no evidence that he was sort of holding them out to the public in any way, or that anybody would know that he even had the checks. And that's why this case is very different from so many of the cases applying 2K. There was just no evidence that he was trying to sell the checks. The government literally said, we'll never know. There was just no evidence to support that.
Well, it seems to me that the manner of theft in this case, because he was a postal employee and the theft almost by definition could not have involved a gun, coupled with the fact that later there were additional checks found without the presence of a gun, seems that the presence of a gun was simply coincidental. And in fact, I imagine many people carry guns in their, on their person or with them when they're traveling. And that there was simply I mean, I can't see any evidence or even argument that the guns were in connection with the possession or the theft here.
Yes, Your Honor, that's completely correct. And I think the point that you make is absolutely essential, that when he did not have the drugs, he did not have the gun. He was stopped twice and his home was searched. The only time he had a gun was when he had the drugs. When he was stopped the second time, he didn't have the drugs, he didn't have the gun. When his home was searched, he had a personal use amount of marijuana, that's all, and he had no gun. So
He also had the gun when he had the $750,000 in checks.
that is true, Your Honor. That is absolutely true. But as I said before, there was no evidence that he was engaged in trying to sell the checks. And I think that points to a reason that this particular enhancement never seems to come up, because you just don't need a gun to commit the kind of crime and to make money from committing the kind of crime that my client was engaged in this particular case. Fraud and that sort of thing, they just don't require guns. As I said, you don't need a gun to go into a Walmart and pass a check that was actually made out to someone else.
Is possession of the gun lawful?
Yes, there was no evidence that the gun was illegal or stolen or anything like that.
So he was simply exercising his right to carry a gun lawfully
Yes, Your
at the
Honor.
time that he was pulled over.
As far as the evidence shows, that is exactly right. There's nothing in the record to indicate that the gun was illegal or stolen. That's right, Your Honor. So in this case, there was just simply no evidence that the firearm facilitated the offense of possessing the checks or stealing the checks. And it's insufficient that even if it had had a dual purpose, that would also not meet the requirements either. It can't be coincidental, which means that he had to have the gun because he had the checks, and would have had the gun if he'd had the checks, regardless of the drugs. But the facts prove exactly the opposite. So in this case, the enhancement just was not appropriate, and the district court erred in applying it. Also, the district court, there's no help in the PSR. The district court did adopt the PSR, but the PSR just merely makes the conclusory statement that the enhancement applied and doesn't support it in any way. It just quotes the language of the enhancement itself. And there was nothing in the factual basis or arguments at sentencing that would have supported the enhancement either.
Let me ask you this. So if we were to agree that with your argument, how the district court here gives an alternative, I guess, alternative sentence. And my guess is the government's going to probably say, if there is an error, that you have Gomez Jimenez, where he says, this is going to be the sentence, even if I am wrong.
Yes, Your Honor.
So if you can, how do you get around that case?
Judge Agee, I see that I only have less than 2 minutes. May I respond to this question?
Sure, it's your time. Have at it.
Okay, I plan to discuss this much further in the second part of my argument, but in a nutshell, this case is unlike
Well,
cases.
you ought to address it now so the government has a chance to rebut.
Okay. The government, first of all, has the burden to show that this serious procedural error was harmless. And in this case, although the government announced an alternative variant sentence, this case is very, very different from cases in which the district court says that it would apply the same sentence regardless, because normally what the district court is doing, it's been presented with a specific guidelines potential error. And the court can say that even if I'm wrong in this guidelines calculation and it would affect the sentence by X number of months, I would still give the same sentence. This is not like that, because in those circumstances, the district court is able to identify a specific impact on the guidelines and say that impact on the guidelines would not be enough to change my sentence. But that's not what happened here. In this case, the district court was essentially flying blind and saying that I would apply the same sentence regardless of any guidelines calculation error that I made. And this flies in the face of Gall, because Gall requires that the framework for the district court sentencing decision has to be a correct guidelines determination, and the district court has to be cognizant of the guidelines at all times. But when the district court just says, no matter what mistake I might have made, I would impose the same sentence, that unanchors the district court sentencing decision from the guidelines. And that's why the alternate variance argument doesn't work here. And the second reason is that in a case like Cox, for example, the district court made it abundantly clear that the district court would vary upward. In Cox, the district court had a specific impact on the guidelines. The district court was able to say, this impact on the guidelines is not enough to change my sentence. And if I had to, I would vary upward to reach the same sentence. Nothing like that happened here. The district court didn't explain or justify why it would impose an upward variance. And in fact, the sentence that the district court imposed was at toward the low end of what the district court believed was the correct guideline range. And there was just nothing in the district court's discussion that would make this court know, which is what the court has to do. This court has to know what the district court would have done. It has to be for assumed error harmlessness. This court has to know exactly what the district court would have done if it had had the correct guideline sentence in front of it. And there are many instances where this court can know that, but this is not one of them. In this particular case, the court can't know that because nothing that the district court said would explain why it would vary upward is such a significant amount if it had had the correct guidelines in front of it.
All right. Thank you, Ms. Haygood. You've got some rebuttal time. Ms. Englander?
Thank you, Your Honor. May it please the court, Kate Englander on behalf of the United States. The district court applied an enhancement because the defendant possessed a loaded gun in a car with hundreds of thousands of dollars in stolen checks. The defendant never objected to the application of that enhancement, nor to any of the facts that supported it. So the government had no further burden at sentencing. And now on appeal, the defendant has the sole burden to show each of the four prongs of plain error review, and it cannot meet its burden.
Let me ask you about this. There's a recent case from this court, I think it's from last year, Henderson. It says that the district court has the independent obligation to properly apply and calculate the guidelines. How is that not relevant here?
So the district court absolutely has the obligation to correctly apply the guidelines. It did so here. But the way
I guess my question is, there seems to be the district court didn't, and in terms of an independent obligation, there's this analysis regarding if the gun was being used, I guess, in furtherance of there's no real analysis there. Basically, I think the district court just says if I get it wrong, it'll say the same. So how is that an independent? How is the district court under Henderson meet that obligation, that independent obligation?
So this court has long held that facts that are in the PSR and are not objected to, the district court can take those facts as true. In this case, the district court
argument that there was a weapon in the vehicle. Lots of people drive around with weapons in their vehicles. Nothing unlawful about that. In fact, I think in many instances that's constitutionally protected. So I don't think that there's a disagreement about that fact. I think the disagreement or the question is the in connection with language. Was there anything in the PSR suggesting that the weapon that was found was used in connection with the charged crime?
There was a finding in the PSR that it was in connection with the crime. That's
Was
at
there a
83
finding or a statement?
It's a statement that the court then adopts when it adopts the PSR. But
What facts are in the PSR that support that?
So I think there are several, Your Honor. First, it is a loaded gun. That, undisputed. I disagree that there's no evidence that the defendant was trying to sell these checks. So first of all, he's in the car with another person who there's a check in the car that has already been altered to reflect her name. That indicates that she's at least a potential co-conspirator. So he's in the car with somebody. The payee line reflects that a check has already been altered into her name. It's again $750,000 in stolen checks, which is, so I think this is a situation where, if Your Honor, for example, the defendant had a loaded a hunting rifle that was locked in the trunk and all of these checks in the car. That's a different situation than this. What we have here is a defendant who is a gun that is loaded, accessible, ready to use, all of these checks in the car. They're all potentially negotiable. That was what the AUSA proffered at sentencing. And frankly, Your Honor, the gun wasn't lawfully possessed here, where I think the defendant basically concedes the defendant was also selling marijuana from the car. It's not lawful to possess a firearm in connection with that. But I think this is analogous to those situations where somebody has an enormous amount of drugs in the car and a gun, because what you have is a huge amount of contraband that the defendant has no ability, for example, if it's stolen, to go to the police and say, hey, somebody stole my stolen checks, right? So there's a need to protect that contraband.
Is he charged with selling checks? My understanding is he was charged with possession of stolen checks and stealing checks. Was he charged with selling the checks?
He was not charged with selling them, but there was an indication, and this is proffered by the AUSA.
But doesn't the in connection with language have to be in connection with the charged crime?
With the crime, or with under 1B1.3 of the guidelines, or with trying to not get caught, frankly. So connection with he's possessing the checks.
Selling them is part of trying not to get caught?
Yes, Your Honor. Absolutely. I mean, it's part of the conspiracy to possess these checks, which I understand that what he pled to was possession of the stolen checks. But in order to keep possessing them and to benefit from that, he has to find a way to turn them into real money.
So, and then I guess looking at your example regarding like the drugs and the gun, I mean, there were 47 checks that were in the trunk. There was one check that was in the car. So if I use your earlier analysis, that seems to help Mr. Franklin, right?
I don't think so, Your Honor. I think if someone has several kilograms of drugs in the trunk and a loaded weapon in the car, I think this court has I can't cite to a specific case, but under those circumstances, the gun is certainly facilitating the possession of that contraband, those drugs.
Yeah, but here it is, the 47 checks, I think, in the trunk of the car, and then there's one check in the car. There's one check in the car in the backpack or something with the gun. So I guess if I'm looking at Mitchell and Bolden, the whole in connection with this is facilitation, and how do we get to that he had the gun to facilitate stealing the checks?
Right. So the legal standard is whether a facilitator had the potential to facilitate the crime. This is a situation where he's in a car, he has an enormous quantity, $750,000 in stolen checks. Even if we're to Judge Egee's point, to assume that there may be worth 10% of that, that's still $75,000. That's an enormous amount of contraband that he has in the car. And the possession of the gun is in connection with that, in the sense that it emboldens him and it protects him in the situation where somebody might try to steal it. Again, I do think there are circumstances here. He's in the car with another person who is clearly a potential co-conspirator. And some of this gets back to the point that if this had been raised as an objection,
Potential co-conspirator, is there anything in the record about that?
one of the checks had been altered to reflect that her name was the payee. That's the check in the backpack has her name on it. And her name was not on it originally. It was not.
So why is that relevant to the fact that there's a gun in the car?
Well, I think it shows if he's dealing with people who may know that he has stolen checks, right? He has a need to self-help. It's the same situation that a drug dealer has when they have customers coming to them, right, who know that they have drugs. They may be in a situation where somebody might try to steal those drugs. Somebody, if people know that you have contraband, you have a need to protect yourself. The person in the car with him, I think the evidence was just did know that. And again, this gets back to the point: the government, if this had been
the fact that her name was on it, and that the other check that was cashed doesn't seem like he was trying to wasn't doing a very good job covering up, because he used his own name. So that doesn't really support your argument that he was selling the checks. It seems like he was cashing them in his name and in the name of his friends.
he cashed one in his name.
And is there anything that suggested he was selling them?
What the AUSA proffered at the sentencing hearing was that there wasn't evidence that he intended to recruit others to, and this is at page 48 of the record, to involve other criminals, have them put their name on the payee lines. Now, if there had been an objection to this in connection with enhancement, the government could have put on additional evidence about this, but because everyone agreed to these facts and the fact that this enhancement applied, the government didn't have an obligation to do that. It had met its burden with the facts that were put forth in the uncontested PSR. And I do think that the Fifth Circuit cases that the defendant cites in the reply brief are readily distinguishable from this case, and so I want to highlight those. In those cases, you have a situation where the defendant has a gun and also like documents that he's intending to send to the bank in order to commit bank fraud, forged documents, fake IDs, things like that. Those are not the types of documents that need to be protected with a gun. They don't have the same inherent value that $750,000 in stolen checks.
Counsel, do you have a case name to go with your description? Apparently you're referencing a specific case.
Oh, yes, Your Honor. I'm referencing two cases that the defendant cited in the reply brief. One is United States versus Fedipe, and the other is United States versus Houston. And those were both cases where the Fifth Circuit found that this enhancement should not apply, but circumstances where the gun really does seem coincidental or incidental to, somebody who's got a bunch of fraudulent loan applications or, a fake ID, essentially. This is a different situation. And I think, frankly, this is a situation that is very close to the Mongarella case, which the defendant also cites in the reply brief, which is an unpublished case in this circuit. But in that case, the defendant possessed a gun at a telemarketing fraud center where he also had about $3,400 in cash on his person. And there, this court found that it was not an error to say that the gun was possessed in connection with the wire fraud conspiracy that he was conducting out of that call center, because the security concerns implicit in holding that much cash. Here we have a defendant who has contraband that is in a value definitely exceeding $3,400. And so I think that the Mongarella case really does support that the application of the in connection with here. And I do want to touch also on plainness of the error. So in order for this court to reverse, it would have to find not only that the district court committed an error in applying the enhancement, but that it was so clear and obvious that essentially the district court should have known it. And I think that there's two ways in which the defendant cannot meet the plainness prong here. So first, there is no binding precedent in this circuit on this specific enhancement, although there is plenty on sort of the parallel enhancement that we've talked about. The one case in this circuit that the defendant has referenced, Mongarella, which is unpublished, I think does, like I said, support application of the enhancement here. But also factually, it's not clear and obvious. Even if the court finds it was error, it's not clear and obvious that the gun was here only to protect the drugs. So I think, opposing counsel referenced the fact that he was later stopped and he did not have no drugs, no gun, essentially. But also, he didn't have a gun, but he didn't have $750,000 in stolen checks with him. So I don't think that supports that position. So the defendant does not demonstrate that the error here was plain, either factually or legally. And lastly, I want to turn to the prejudice prong. And first, I want to respond to the argument that the defendant made in their reply brief about the application of the 0-point offender guideline. What the counsel says is we can only infer that the PSR didn't apply the reduction based on the incorrect conclusion that Mr. Franklin possessed a firearm in connection with the offense. That is not enough to meet their burden. And so this is another point I want to make. Defendant says that it's the government's burden to show that the error was harmless. That is not true where we are on plain error. The defendant has the burden to show that he was prejudiced by the error, and he cannot meet that here. But as to 0-point offender, so defendant can't meet their burden on that on this record. I'm not sure that 0-point offender would have applied. Defendant would be ineligible for that if what he did caused a substantial financial hardship. I don't know, the government didn't have an opportunity to put on evidence of that. I know that it's a very high bar to show. I don't know if the government could have done it here or not. But again, the defendant has the burden to show that it definitively would have been bad, and I don't know that that's the case. The record, page 84 of the JA, there are some victim impact statements. One person described basically having to partially close her small business because she was never able to get the $3,000 check that went missing. So I think there is at least some indication that he may not have met 0-point offender, but we don't know for sure, and we can't know because the defendant never raised this. But even if the defendant is right that he would have been a 0-point offender if that guidelines application or enhancement was applied in error, and if that error was plain, even if the defendant's right about that, it's a 48-month sentence is still a relatively small variance and not significant compared to others that have been upheld. And lastly, I want to address the alternative variance. So defendant basically says it can't stand because the district court was unaware of this, what they claim is an error. And so therefore it wasn't anchored by a potential alternative guidelines range. That is not the law. So first, the defendant is assuming, contrary to what the district court said, that it would have given a different sentence if the guidelines had been different. What this court has said in Gomez-Jimenez, Hargrove, Savion-Matute, and as recently as last week in the Roy case, we take the district court at its word. When it says that it would have given the same sentence, we take it at its word.
But doesn't the district court have to give us some explanation as to why to the upward? I mean, if we look at Gall, doesn't the district court have to give us some explanation as to why? I mean, here the district court gave no explanation. District court just says I do think I properly calculated the advisory guidelines, but I announced pursuant to Gomez-Jimenez and Hargrove that I'd impose the same sentence. Doesn't it have to be an explanation as to why he would impose the upward variance?
The district court has to say that it would give the same sentence, and it has to be substantively reasonable. I don't believe that there's any additional requirement.
But when be substantively reasonable, we have to have a reason. There's no reason here. He just says I would give the same sentence. That's the concern, is that you have to say why you would have given the upward variance. You can't just say I'm going to do the same thing. It's kind of like, that seems like what the district court said here.
So the guidelines are advisory. With the district court can take, as this court said in Roy last week, can take the measure of the man. So it has to, in order for the alternative variance to hold, there are two parts to it. The defendant the district court has to say that it would give the same sentence anyway and make that clear, which the district court did. And then that sentence has to be substantively reasonable. And that's where the explanation piece I think that Your Honor is referring to comes in. Here, the district court extensively considered the 3553A factors. So it acknowledged the mitigating arguments that were in this case, the fact that it credited the defendant's military service, the fact that he was trying to help his family, that he was the sole caretaker.
But doesn't Gall tell us that if district court says the district courts are to give their reasoning when imposing an above the guidelines sentence? Because it would be above the guidelines if he is in fact wrong, right? So I think Gall says if you're going to do something that would be above, you have to give a reason.
The district court obviously didn't think it was giving an above guideline sentence. But what this court has said
repeatedly, he does say if I didn't calculate it right, this is what I'm going to do. If I didn't calculate the advisory guideline range right, then this is what I would do. So it's almost as if he's contemplating if I'm wrong, and it is less, then this is what I would do. I'm going to leave it at it is still going to be the same sentence. But he doesn't give a reason.
Well, I think the district court gives a reason under all the 3553 factors for that sentence, and that is the reason. Because the guidelines are advisory and the district court is obligated to take into account the full totality of the defendant's circumstances, which this district court absolutely did. It said right up front, I'm going to consider the totality of of the defendant's life, the good, the bad. And it did consider all of those things, including, in this case, the extraordinary need for adequate deterrence of other potential postal employees who might want to steal mail. So, and to Your Honor's point, I think Melina Martinez also addresses this exact issue where it says, most of the time, the district court is going to have to correctly calculate the guidelines range, but there could be circumstances where the district court says this is the correct sentence for this person, and therefore, even if there's an error, it can be affirmed. So it explicitly contemplates that situation in that case, and this court has repeatedly upheld alternative variant sentences under very similar circumstances, including in the cases that are cited. And again, I think the court did really address the unique characteristics of the defendant in this case in coming up with that 48-month sentence. That sentence was reasonable in light of all those 3553A factors. And based on that, this court should affirm. Unless the court has any questions, I'll yield the remaining time.
All right. Thank you, Ms. Englander. Ms. Haygood, you've got some rebuttal time.
Thank you very much. First of all, I just want to briefly note that I believe the United States is conflating two different types of prejudice. The defendant does have the initial burden under plain error to show that his substantial rights were affected. In other words, that the sentence was different than it would have been otherwise. But in Gall and Melina Martinez, in Melina Martinez, this court has said that without more, in most cases, showing that the district court applied the guidelines incorrectly satisfies the defendant's burden to show that his substantial rights were affected. And that's not the same as the fact that on harmless error, the government has the burden to show that the sentence would have been the same regardless, that the defendant's ending sentence wouldn't have been different. The next thing I want to emphasize is that harmless error only applies, as this court said in Sisson, when this court knows a district court would have reached the same result because it tells us that it would have done so and it explains why. And that is such an important point because although in Cox, this court recently said that the district court, that this court takes the district court at its word, I think that you can't just take that and run with it because the cases show that that does not mean that once the district court says alternate variant sentence, boom, those are magic words. That's not what it means. The cases illustrate exactly the opposite. This court does, in fact, look to see if the court justified and explained why it would reach the same sentence regardless. And in Cox, the court did exactly that. But in this case, the court did not do that. The court the court sentenced the defendant to what the court thought was toward the low end of the guideline range. In order to have sentenced the defendant to the same sentence, he would have had to vary upward by 11 months on top, to add 11 months on top of the high end of
The 11 months is what you had in your reply brief, but your opening brief said 2 months.
Yes, Your Honor, that's correct. That is because I originally missed the fact that in addition to failing incorrectly applying the enhancement, because the court did that, he also failed to give Mr. Franklin credit 2 levels down for the fact that he was a 0-point offender. And that is the reason for the bigger difference, the 4-level difference as opposed.
I understand the problem, but I mean, here we're not only on plain error of review, but we have 2 briefs from the same party that reach different conclusions.
Your Honor, I apologize for that, and that is completely my mistake. That originally I did not.
So, Hagood, wasn't your original brief an Anders brief?
Yes, Your Honor, it was. Yes.
And so it was, so it wasn't a regular appellate brief, it was an Anders brief.
That is correct, Your Honor. And this court ordered the government to file a brief and then allowed me to respond to that brief. And so this court did its job and flagged the issue. I had originally raised the issue that the enhancement wasn't justified, but I didn't realize that my client could show substantial error under Gall. I mean, that his substantial rights were affected under Gall already. And I also thought that the difference was only 2 months, but I corrected that in my reply brief. And the difference is actually 4 months, and it's a significant error, and it substantially affected my client's rights. And the government can't meet its burden to show harmless error. And assumed harmless error review doesn't apply because it's not clear what the district court would have done had he had the correct guidelines range in front of him. My time is over. Thank you.
I want to thank both counsel for their argument. Ms. Haygood, we want to give our special appreciation to you. You're court appointed. That's a vital function. We could not perform our function if it weren't for lawyers like you who step forward and agree to undertake those tasks. So obviously we can't come down and greet you as we normally would, but hopefully we'll have that opportunity in the future. So with that, we will take the case under advisement and issue an opinion in due course, and we'll now take a 1-minute break while they switch out to the next case. All right, we'll take up our next case, which is United States versus Hodges. Mr. Byrne, we'll hear from you.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Jonathan Byrne. I'm appearing this morning on behalf of Gary Hodges, the defendant below. Mr. Hodges was convicted of 2 counts of the attempted enticement of a minor, but there were no minors in this case. The alleged minors involved, ages 11 and 13, were creations of law enforcement. Regardless, Mr. Hodges' guideline range was greatly enhanced because of provisions relating to minors. The plain reading of minor, an actual person who has not reached 18 years of age, is unambiguous. As a result, the guideline commentary expanding the definition to include fictitious minors cannot control.
Why do you say it's unambiguous?
Because it is a term that is undefined in the guideline itself, and therefore we apply the ordinary and natural meaning. And if you look, we laid out a bunch of dictionary definitions, including Black's Legal, and they all point to the fact that a minor is a person, is an actual individual who has not yet attained the age of 18. I think if you went out on the street and asked 10 people what a minor was, what that meant, none of them would say that that meant a fictitious person that was concocted by law enforcement for part of a sting operation. And so the way that
we have lots of cases. There's one, U.S. versus Kelly, and in footnote 7 of that case, it goes through a long laundry list of cases and concludes they've all uniformly rejected the argument that an actual child must be placed at risk.
in order to sustain a conviction, yes, Your Honor, but I think that's a different question as to whether the guidelines apply in situations where the minors are fictitious. The fact that
the statute gets to use a lesser term than the guidelines.
not a lesser term necessarily, Your Honor, but a term in a different context, and in a situation where the guidelines the commission can be more specific generally than the statutory language can be. And if the commission had put the definition of minor that included fictitious minors in the guideline itself, I wouldn't be here. But they did pretty much exactly the same thing that happened in Campbell. You have a term, and then in the commentary they say, well, this term also includes these other things. And the commission can't do that unless it's resolving some sort of ambiguity. And in this case, there really isn't an ambiguity because
Well, let me ask you.
Yes, go ahead.
Because I think this is a little different than Campbell, because Campbell, there was this conflict between the actual language in the statute and the guidelines expanded and added additional I guess crimes. Here the guy in here the commentary just defines what a minor is, and it says it can be a fictitious person, law enforcement person.
Yes, but I still think it leads to the same result, which is that the guideline itself, the reach of it gets expanded by the commentary in a way that is not appropriate under Campbell and the related cases.
So do you have a case from anywhere that says in this context, any of these statutes that relate to children, that the child must be an actual child?
I do not, Your Honor. I can't point this court to a case that says this is what the district court should have done below. We're sort of arguing from the principles, again, in Campbell and related cases about how the guidelines and the commentary interact.
Let me ask you, and follow up to Judge Agee's question. So, in looking, if I'm looking at, I guess, legislative intent and statutory construction, if I'm looking at the legislative intent, so you have this enhancement that deals with the attempt, right? This is all about an attempt. And then there's another enhancement, I think is 2G1 3B4A that actually deals with if there's actual contact. So if there's actual contact with a minor. So you have an attempt, this is an attempt enhancement that he gets, and then there's one that actually deals with the contact with the minor. So it seems as if there's some consideration there um based on this being an attempt enhancement rather than one when you're an actual person.
Certainly, the guideline draws a distinction between an offense that leads to contact and one that does not, but that doesn't necessarily turn the other enhancements don't necessarily turn on whether there is an actual minor or not. Obviously, if there's contact, there would have to be an actual minor.
Well, I guess my point is that the statutes or appear to the focus on this one is the attempt, the whole attempt of the enhancement, whereas the other one is when it actually happens.
There is an additional enhancement that does apply when a sexual act does actually occur, but I don't necessarily think that undermines the argument as to the others. Because of course, if there was actual contact and there was an actual minor, this issue wouldn't be part of the case. You could also have situations where there are actual minors where the offense doesn't progress to involving contact, and so those enhancements would apply in those cases, whereas the contact enhancement would not.
See, with applying the enhancement or the commentary here, is that the commentary defines the word minor for the entire, frankly, for the entirety of all of the enhancements here. And some of them, by definition, couldn't apply if the individual was fictitious. A fictitious individual, for example, couldn't have been killed or couldn't have been, frankly, there couldn't have been the actual contact. And so because the application of the commentary seems to provide a definition that necessarily wouldn't work for what seems to me the vast majority of the enhancements that it's referring to, I'm struggling with how this commentary could even be applied to this long list of enhancements.
Well, I don't necessarily disagree with that, Your Honor, and I think that actually sort of bolsters our argument in that shows that the definition of minor has to get stretched to apply to these situations where there are not actual minors, because the definition of minor itself.
That's why I'm agreeing with you for
okay.
a different reason, that this definition isn't limited to the enhancements that are at issue here. The definition applies to all of the enhancements, or excuse me, the commentary applies to all. The definition in the commentary applies to all of the enhancements, and for that reason, it seems to me that it's really amending in ways that were not contemplated, at least not by Congress in adopting the enhancements themselves.
That's correct, Your Honor. I apologize for missing your intent there initially, but yes, I would agree with that. Of course, we are here on plain error. Our position is that not only is this error, it is plain because it is contrary to cases up through Mitchell that explains how the commentary interacts with the guideline. It affected Mr. Hodges' substantial rights. His guideline range would be orders of magnitude less without these two enhancements, particularly the 8-level enhancement that applied because one of the fictitious minors was 11 years old. And it's also one of those cases that falls within the Rosales-Morales holding from the Supreme Court that says these situations generally are going to be the kind of ones courts should notice on plain error.
Error really be plain when you admit there's no settled law on this question anywhere? It's not even settled law. There's not even a single case, as far as I haven't been able to find it.
As I said earlier, I can't point you to a case that says this, but I think there are general principles from long established Fourth Circuit precedent about how commentary and the guidelines interact. And I don't think for error to be plain, it has to be that granular. That would effectively really narrow plain error review to almost a nullity. If there aren't any further questions at this point, I will reserve my time. Thank
All
you.
right. Thank you, Mr. Byrne. Ms. Harold?
Thank you, Your Honor. May it please the court, Jennifer Harold on behalf of the United States. The district court did not plainly err by applying these enhancements under 2G1.3. There was no objection. There is absolutely no case law that says the term minor is an unambiguous term that refers only to real children. Such a reading is inconsistent with the scope of the offenses that are covered by this particular guideline. And
You're saying the term is ambiguous.
I think the term is either ambiguous in that the definition of minor, even the ones put forward by the defense in their brief, are not consistent in exactly the same way. In fact, they're somewhat vague. One of them says an age, the others say someone who is a mature adult. So I think that this is not a term that unambiguously covers only real children. And to the extent that it is unambiguous, I think it unambiguously would be consistent with the scope of the statutes, which would include fictitious minors.
What's applied here was the enhancement, and the enhancement says minor. And so are we to look to the commentary?
I think in this case, if we determine that the word minor is not unambiguously referring to only real children under the age of 18, then precedent would demonstrate that we look to the commentary if it has a definition. And this is simply a definition.
This is where I'm struggling. What do you do with my question that I asked your friend about the fact that this definition of minor, which is very long, it doesn't just say real or fictitious. It actually goes on and talks about a real or fictitious minor, but only in the case where the law enforcement officer was creating the fiction. So if I created the fiction or you created, well, if anybody else, a person created the fiction, and in fact, I think we have a case that says this, then it doesn't apply. But it does apply to the specific kind of fiction. That seems to me an expansion on what was even intended in the enhancement itself.
Well, I think what the enhancements, I think to answer that question, it's important to look at the purpose of the guidelines in a very broad context. The purpose of the guidelines is to limit and reduce unwarranted discrepancies between sentences for two people that basically committed the same offense. And for 2422B, the offense is not the sex act. The offense is their attempt to persuade. And Mr. Byrne pointed out, there are going to be situations where someone might have attempted to entice a real minor. They might have gone through all the steps, but never consummated the act. And there's absolutely no...
Couldn't that then, that you're certainly right, but couldn't that have then been a fiction created by somebody's enemy that wants to entrap them and creates this fiction? So then you have the person could have done the exact same thing as the defendant here, but the minors were created by somebody that was not law enforcement. And I think that you concede that the enhancement would not apply, the enhancements would not apply in that circumstance. And so where I'm getting stuck is the fact that this commentary both doesn't apply, the definition in the commentary both doesn't apply throughout the enhancements, because some of them by definition it couldn't apply. You can't kill somebody that's a fiction. And and in addition to this disparity argument that you're making, well, then you have another disparity. The defendant could have done the exact same thing. And if the person making up the fictitious characters was a person that was not law enforcement, these enhancements would not apply, I think, under your logic and under our case law.
I would agree with that, Your Honor. The way the definition is, it has to be law enforcement. And I think that goes exactly to your point. It would prevent someone from getting this enhancement if it was their neighbor that they were disputing a property boundary with who went after them in this manner. It is something where this law
I agree
enforcement.
with you. It's great public policy. It's just not written in the enhancements. And it's not our job to legislate public policy.
I understand that, Your Honor. I would put forward that this guideline actually does follow exactly with legislative intent if you follow the definition, because the legislative intent and this case law, Judge Agee cited to the Kelly case. This district and every other district to address, or every other circuit to address the issue, has stated that these statutes are not focused on the outcome.
When we're talking about the statute, we're talking about the guideline. Is there a case that says that about the guideline? And are we really supposed to be looking at the legislative history of the guidelines?
Well, I think it goes sort of a two-step analysis. Congress comes up with the statute, Congress approves the guidelines. And I think it's a reasonable conclusion that Congress intends for the guidelines to match their statutes. In this case, you would create a huge disparity between people who engage in the exact same crime, the exact same criminal act, and there would be a 10-level swing, for example, in this case, between those two individuals. And that, I think, in turn goes to another point in this plain error review context. This is not a case where notice should be applied. In this case, if you give this person who did the exact same thing, it just happened that law enforcement proactively intervened before he could rape an 11-year-old, and we were to give that person a huge windfall through no effort of Mr. Hodges. He was, I'm sure, very disappointed that he did not get to fulfill his wishes. The public and the public reputation of the judiciary will be substantially damaged. So even if you were to find that this was plain error, this is not a case where that plain error should be noticed. This is something that it would be a different scenario possibly if the objection had been raised. I believe the outcome would be the same, that this enhancement, like in every other circuit, no circuit has ever found that this definition should not be considered. And I do not think it falls squarely under Campbell.
Found that this enhancement should be applied to a fictitious minor created by law enforcement? This enhancement, has it ever been found by any circuit that it should be applied?
I mean, it's been affirmed in a number of circuits. Since we were looking
But
at
is
plain
this
error,
the issue that we're talking about, whether or not this enhancement applies to this circumstance? Is the case address that question?
in others, I mean, there's nothing in our circuit. I don't think that there's cases that have affirmed sentences where this was applied. I've had this particular enhancement applied in probably 24 of my cases that were essentially the same undercover operation. It has never been, and since we're in the plain error context, it has never been found to not apply in these circumstances. And I don't know that there is generally not a challenge made to this in this context, which is why it wasn't objected to in the district court. But so I can't cite to you a specific case where they affirmatively found that this, I'm sure they exist in other circuits. Given the plain error review, I did not delve that deep into that, Your Honor. I apologize.
I didn't find it.
I wanted to touch a bit back on the distinction between this and Campbell. I think Judge Benjamin made a very good point that Campbell was dealing with essentially two definitions. You had a definition in the guideline and a definition in the commentary that conflicted with one another. Here we have a word. And a word, particularly a word that is not in the context of another list where we can look at the scope of that list, it is a word that is used in the statute. It's a word that is used in the guidelines, but it is a singular word. And Campbell is a much more obvious discrepancy between the guidelines and this. And to Mr. Burns' point that it would make a nullity of plain error in this context, well, plain error is supposed to be difficult to challenge. And the Limbaugh case in this district, it was an authored but unpublished opinion, did find that an analysis under plain error with Campbell has to show that that particular guideline has been found to be unambiguous and that a conflict was created. So it is granular, and it should be. because Campbell is a very complex analysis, and to put it under plain error review when there's never been any case law addressing that particular guideline, it's an extremely guideline-specific interpretation. So I think it is appropriate that this is a very granular issue focused on just this word. And this word, I think, even if you would agree that the definition of minor is 18, which varies from state to state in different contexts. You know, a minor is able to consent to sex at 16 in many states. The definition itself, even the ones that were cited, simply say a person. And there is no law that says the word person unambiguously refers to a real person. I mean, if I were to say, Mr. Byrne pointed out, if you went to people on the street and asked them a question, I think if I went up to people on the street and said, Harry Potter is a person, no one's going to think, or a minor, I don't think anyone's going to say, well, you're using the word minor incorrectly, because a minor can only apply to real people. And I think that's important. We're just looking at, is the only reasonable interpretation of this word, minor, that it applies unambiguously to real people. And I do not think that we can say that. And therefore, the guidelines allow us to look at the commentary definition.
So let's take us back to the commentary and your Harry Potter hypothetical, because here Harry Potter is a fictitious minor, but not, as far as I know, a law enforcement officer represented to a participant. So even under your hypothetical, the Harry Potter wouldn't apply. And so how in the commentary do the drafters of the commentary get to amend what was adopted and really substantively change what was adopted by Congress in adopting the enhancements?
Yeah, my hypothetical went to, because I think first step is just looking at the word minor by itself, because we look only at the text of the guideline. And so we're looking at minor without looking to the commentary to ask, is that word unambiguously referring only to real people? And the Harry Potter example is, I think, to say, look, the word minor is not unambiguously in the English language referring only to real children. Now, I would agree with you, Harry Potter is not a good example for falling under the commentary because he's not law enforcement. But until we find that the word minor itself it unambiguously refers only to real people, we don't need to go and see, is the commentary covering every possible scope of minor? The question is, does this word have only one reasonable interpretation? And is that one reasonable interpretation that it must apply to a real child? And Congress obviously didn't think that minor needed to have that definition when it created these statutes, because it wants to convict people on both ends, because they're committing the same crime. They are going forward, they are working to persuade a minor, and that's the crime. Whether a sex act occurs is frankly irrelevant in these statutes. They have engaged in the same exact conduct, and the guidelines are meant to make sure that two people that engage in the same conduct get the same sentence. That's what the statutory purpose of the guidelines is. And the only way that this word can be read to comply with the statutory obligations and the actual statutes that the guideline refers to is to interpret it to incorporate more than one reasonable explanation. And once we hit that point, once we hit that this is ambiguous, there's at least two rational conclusions as to what minor could encompass, then that's when the commentary becomes authoritative, and we can turn to that.
The commentary have to be authoritative with respect to every aspect of the guideline, because I think clearly this commentary can't apply to all of the aspects of the guideline. It can't apply to the aspects of the guideline where you need to have a real person.
Well, I mean, many definitions are going to have, a word might be defined to include a number of different aspects that aren't always going to be with every enhancement. But to say that two people that attempt to have sex with an 11-year-old and one succeeds and one doesn't is going to be the difference between one getting a 41 as their offense level and one getting a 31 as their offense level.
That's the case here. If the fictitious minor was created not by law enforcement, that would exactly be that fact pattern.
Which is why that is, again, that is reasonable. They're expecting, and the statutes, and honestly, the way these statutes are implemented, they generally are either a real minor or law enforcement. We generally don't like to, there's a lot of complications in trying to prosecute something where a random person in their basement has created a fictitious minor. There's not a control factor. We can't go meet that person to intervene until law enforcement becomes involved in advance. So those cases would be highly unusual. I have never seen one in the Southern District of West Virginia, for example. So the guidelines as written with this definition would apply to almost every possible scenario that's actually going to be sentenced in a federal court. But either way, I think that there are times where a definition is not going to perfectly match an enhancement. And that's why those enhancements, such as the Sex Act or really the parent guardian one, for example, those do require a real minor. And that distinguishes between someone who has actually harmed a real minor and someone who hasn't. But because the guidelines want to distinguish between those two different types of defendants, doesn't render that definition inappropriate. It's not directly in conflict with the word.
I'm not suggesting it's inappropriate.
Pardon?
No one's saying it's not appropriate, but appropriateness isn't the legal standard.
That's fair, Your Honor. I think it is something that courts have to defer to because the word is not unambiguous and the definition is not inconsistent with the statute. It's narrower than the statute in that it could be, the statute could cover, as you said, a neighbor pretending to be fictitious. The statute can cover that. The fact that the guidelines want to make enhancements narrower than that or make a definition narrower than that for purposes of the enhancements doesn't mean that that definition should not receive the deference that definitions normally would in the commentary when they're dealing with an ambiguous term. I think I've covered all of my major points, so unless there are any further questions, I would submit that this is not plain error. Even if it was plain error, it should not be noticed because that would drastically undermine the public reputation of the judiciary, and that Mr. Hodges' sentence should be affirmed.
All right. Thank you very much, Ms. Harold. Mr. Byrne, you've got some rebuttal time. You're on mute.
Yep, there we go. Yes, I wanted to just address a couple of the things that Ms. Harold brought up. One of the things is she mentioned our definitions of minor that we put in the brief and that they're ambiguous in some way. They are not ambiguous in the fact that 3 out of the 4 of them require a person, and the third one requires someone who is defined as a child, i.e. real people. None of them suggest that fake people would meet that definition. Certainly they could if in a particularized definition, but in a general common meaning sense, they just don't. One of the things I think it's important to consider here is that the guidelines are a blunt instrument, and the courts recognize that in other situations like a career offender situation. The largest part of the enhancement in this case was the 8-level enhancement because one of the fictitious minors in this case was 11 years old. That's a decision that's entirely in the hands of law enforcement. So law enforcement essentially can control whether that 8-level enhancement applies simply by adding a second minor, by making the minor younger than 12. That doesn't change the actual acts that Mr. Hodges engaged in. And so at the end of the day, the actual acts that any defendant actually undertook are 3553A factors. The judge is absolutely free to consider them. And if the guideline range is inadequate, to vary upward based on reasonings that are found in the record. But the guideline range itself has to be correct, and that's the kind of anchor and lodestar the Supreme Court has said over and over again about how important they are. And so it's a world of difference between a 121-month guideline sentence and a 324-month guideline sentence. It's much more difficult to talk down from 324 than it is maybe to talk up from 121. And so I think that's an important consideration when considering this. But I think that covers everything. Unless there are any questions, I'll rest on my brief and ask that Mr. Hodges sentence be vacated and the case remanded for resentencing.
All right, thank you very much. I want to compliment both counsel on excellent arguments. We'll take the case under advisement and issue an opinion in due course. As you know, we normally would come down and greet you in person, but obviously we can't do that. So we hope you'll return to the Fourth Circuit when we're in person. And so with that, we'll take a very short recess and come back and do our third case.
This honorable court will take a brief recess.
take up our third case, United States versus Wobble. Mr. Byrne, you are back on.
Thank you, Your Honor. May it continue to please the court, I'm still Jonathan Byrne. I'm here now on behalf of Charles Wable, the defendant below. Mr. Wable's sentence is procedurally unreasonable for two reasons. First, there's an incorrect calculation of his guideline range due to the classification of a prior West Virginia offense as a controlled substance offense when records show that's not the case. Second, the district court failed to address Mr. Wable's
None of those records were in the district court record.
That is correct, Your Honor. I'll start with that issue. So Mr. Wable was convicted of 2 counts, but the count that drove his guideline calculation was the count for being a felon in possession of a firearm. And his base offense level under 2K2.1 was enhanced because of 2 prior controlled substance offenses, one of which was a conviction in Clay County, West Virginia for what's labeled in the pre-sentence report as cultivating marijuana. There is no such offense under West Virginia law. Cultivating is a species of production, which is a species of manufacture, but there's no label for cultivating marijuana in West Virginia. Mr. Wable.
Well, if it's subsumed within manufacturer, what's wrong with the indictment having said cultivating?
I don't think the indictment actually did say cultivating. The indictment, if you look at the records, charges manufacture under the general West Virginia drug statute.
Right. Well, if cultivation is part of manufacturing by statutory definition, I don't understand your argument.
But the argument isn't that cultivation doesn't fall under that statute. It's that as a label for an offense, it would be the equivalent to an offense in West Virginia that's labeled third-degree murder. There is no such thing. The conduct probably falls under voluntary manslaughter, and in other states might be classified as a third-degree murder, but there is no such thing in West Virginia. And so that's what drew me to go look at the records, because I was like, there's something not right.
But in
here.
that example, there'd be no third-degree murder in West Virginia. But here, the statutory definitions say what they say, and cultivation is included in those.
Yes, and if the records show that he was convicted of cultivation or manufacture as cultivation, then this argument wouldn't be part of this appeal. The problem is that the records actually show he was convicted or he was sentenced for attempt under the general West Virginia attempt statute. And that, to return to our
West
prior
Virginia,
discussion,
could you get a sentence of 1 to 5 years for attempt?
I am not certain what the statutory sentence for that is, but regardless, he did. In this case, I am certainly willing to concede that there's some sort of mistake that happened in 2007 in Clay County when Mr. Wable got sentenced, and that neither party at the time had a reason to seek review to correct it. But the fact is, those are what the records show, and that's what we in federal court are left to parse out. And so we can't really go beyond a record of conviction that says he was convicted of attempt.
The commitment order says he's guilty of the felonious assault of cultivating marijuana. So, I mean, your burden here is to show clear and obvious. I mean, how can you show that this is clear and obvious?
I think we can show that it is clear and obvious because had these records been presented to the district court, it could not have found that this was a controlled substance offense. They're at best ambiguous. At worst, they clarify what he was convicted of, and it was not manufacturing a controlled substance. And this
well, I mean, if it's ambiguous, how could it have been clear and obvious to the district court that would be error?
Should have been clear and obvious, again, because this tag of cultivating should have raised red flags to attorneys who practice in West Virginia. And even putting that to one side, Mr. Wable did, in a pro se pleading, say this is not a controlled substance offense. Now, he did it on a different basis, and his attorney decided not to take that up. But this was certainly not a situation where this issue just kind of slid under the radar at sentencing, and then now we're bringing it up on
Well,
appeal.
it seems to be unclear as to what statute, which West Virginia statute he was sentenced under. So why would that not be clear and obvious?
Well, I think it is clear and obvious because the sentencing order says it was under the West Virginia attempt statute. Whether that makes sense in the general scheme of West Virginia law is not for this court to decide, I don't think. This may be, an error in Mr. Wable's favor. And as I said, neither party had a reason to try and clarify it or correct it. But the sort of ne plus ultra of prior convictions in federal court is that we look at what the person was actually convicted and sentenced of or for. And in this case, that is what it says, as unusual as that appears. This court had ordered some supplemental briefing on what.
Let me
I'm
ask you,
sorry.
but the other issue is that you're saying it is clear and obvious area, but to make the determination based on additional records that the district court didn't even have. How's that? I mean, if district court didn't have it, how is it clear and obvious?
My point, my position on that, Your Honor, is that this is a question that courts can resolve by taking judicial notice. We don't need additional fact finding or anything like that. And so we can look now at the question of whether it is
We're
right.
here on direct appeal under plain error. This is not a 2255 proceeding
Correct.
where that might be a much more relevant question.
We think this could be presented as a 2255 issue, but I think the ability of this court to take judicial notice of those records would allow this court to find that there was plain error in this situation. I was going to turn to the Fowler case, which this court ordered supplemental briefing on. There are several distinctions between this case and Fowler, such that I don't think Fowler controls. Primary ones are in Fowler, the records that the government presented on appeal in that case actually clarified that the district court did not err. And in this case, they go the opposite way. But the other thing that has changed since Fowler was decided, and I think it was Judge Benjamin who brought this up during the first argument, is the Henderson decision. Henderson not only says that district courts have an obligation to correctly calculate the guideline range, but that obligation exists regardless of the arguments that the parties made before it.
Henderson was not a plain error case.
It was not, Your Honor.
And the court there also said, we can't fault the district court for not addressing objections it didn't know about.
It's true, Your Honor. Of course, that in this case there was an objection. It was pro se, and it was not adopted by counsel, but it was there. And so this is a situation where I think maybe the district court should have said, hold on a second, we have this thing here. Let's make sure we get this right. That's why I said it's not a situation
his
where
objection was, marijuana can't be a controlled substance.
correct. It was
Which
not.
has nothing to do with whether or not there's some dispute about the underlying state conviction documents. I mean, if
That's
that
correct.
were the rule, then you would never finish a federal sentencing proceeding.
I agree, Your Honor, that Mr. Wable's basis for the objection is not the same basis as the argument I'm making now. But he nonetheless, he did highlight it. And so this isn't the situation where there was no sort of red flag to the district court that there was something here. Because I have had cases before, Henderson being one, where the district court said, hey, parties, something about this enhancement not applying or applying. I think you should brief this. I think you should you should take a look at this. And I think in a situation like this where you have Mr. Wable saying, hey, there's a reason to think these guidelines are improperly calculated, that the district court perhaps has an obligation to pry into that a little bit more than otherwise. I'll turn briefly to our second argument, which is the failure to address a non-frivolous mitigation argument. Mr. Wable filed a lengthy pro se sentencing memorandum prior to sentencing, and then also had a lengthy allocution during sentencing where he related to the district court an incident that happened at the regional jail after the first night of trial, where he was assaulted by guards at the regional jail. He was denied some medical attention that he needed, and he put that in his sentencing memorandum as one of the bases on which he should receive a downward variance. The district court did note the irony of Mr. Wable talking about essentially being bullied, given his criminal history and some of his conduct in this case, but that is not the same thing as addressing a non-frivolous argument for a reduced sentence. The district court's explanation for its sentence focused on his conduct, lack of remorse, and criminal history. Did specifically note his upbringing, which was part of the same argument that he made. So we know the district court was aware of what was in that pro se sentencing memorandum, but there was no engagement with it. And I don't think this is an error that the government can prevail by saying it is harmless. The sentence that was imposed in this case was an upward
Well, the
variance.
district court did tell Mr. Wobble on a number of occasions, look, I've read everything that you've sent me.
Yes, Your Honor. And unlike the objection to the PSR, the district court specifically asked if counsel was adopting. The district court didn't do that with the sentencing memorandum. I think the record shows that he read it, was aware of it, but nonetheless didn't engage with it. And that engagement, could have been a rejection, but we don't know that. And so looking at the error to see if it's harmless, this was an upward variance. And so I don't think, so there's no presumption of reasonableness of the sentence imposed. And I don't think failing to engage with an argument for a reduced sentence is necessarily a harmless error simply because you otherwise explain why you might have imposed a variance. If there aren't any further questions, I will wait for my rebuttal. Thank you.
All right. Thank you, Mr. Byrne. Mr. Coger.
Thank you, Your Honor. May it please the court. My name is Andrew Coger. I'm representing the United States in this matter. We would request that the court affirm the district court's judgment on sentencing because it did not commit any error with respect to either the finding as to the underlying conviction and from West Virginia for Mr. Wable or in addressing the mitigating arguments by Mr. Wable as well. With respect to the first issue, the bottom line, Your Honors, is that this court's precedents and the rules of criminal procedure permit the court to adopt an undisputed PSR finding, and in all events, that finding cannot be clear or obvious error where the underlying record is neither clear nor obvious. Now, the threshold issue that has been presented really more recently in the reply brief and in the supplemental briefing is an issue of burden. And just to make something clear that the government met its burden below at the sentencing level. In acknowledging the application of the plain error standard review in its opening brief, counsel effectively conceded the failure to properly object to the disputed PSR finding, citing the Lawson case, which indicated that a party must alert the court to a specific reason for the objection. And that's why we have plain error review right now, is I think is still conceded. And in any event, there's...
What about the court's decision in Henderson and the independent obligation of the district court to confirm the guidelines range? Because here, I think, had the district court done so, it would have either determined that the conviction was under the general attempt statute and therefore didn't apply, or it was under the Uniform Controlled Substances statute, and then would have had to then engage in legal analysis under Campbell to determine if it qualified. So none of that happened.
That's correct, Your Honor. Henderson states a basic principle of the court's obligation to do that independent review, but factually it's an opposite. Henderson involved a situation where what was under review by this court was the district court's allowance of the government to file objections outside of the normal time to file objections. That didn't happen here. There's no dispute that there was never an attempt, much less a fulfilled attempt, to object to the issue that's before this court now. So really on its facts, Henderson is not applicable. We absolutely agree that the court has an independent obligation to correctly calculate the guidelines. But on the other hand, Your Honor, the defendant has an obligation to present in specific and direct terms an objection to the court, to highlight for the court that there's an issue with his conviction. And as the court recognized in Fowler.
So you don't think that his pro se objections that he did not withdraw count here?
No, Your Honor, in as much as they don't specifically articulate the reasons that are before this court now as to why that conviction shouldn't be counted. The court's precedent's clear on this, that the defendant has an obligation to specifically articulate the reasons why the conviction shouldn't be counted. And as it relates to the issue of whether or not it's a controlled substance offense under the guidelines, I don't believe there's a dispute here. The defendant failed to do that. So
To me, that it's the same statute as in Campbell, and there was no analysis as to whether it qualified. Now, we could find that if we did the analysis ourselves, that it's divisible and that it does qualify, but it is odd to me that the district court didn't do that analysis. It's the exact same statute. I would think that post-Campbell, every time that statute is the basis, it would be analyzed to see whether it qualified.
Well, Your Honor, I understand that, but in my experience in the district courts here, unless the party objects, that's often not going to get raised, especially when you have, in this case, a manufacturing charge. And so I can only assume, Judge, it was never raised, so I can't say for certain, but I can only assume, Judge, that the district court recognized implicitly that a manufacturing or cultivating charge, as it was characterized in the PSR, is distinguishable from the delivery offense that was at issue in Campbell. So in any event, Your Honors, Mr. Wable did not properly object below. And as I indicated in the Fowler case, there's an affirmative duty for the defendant to do that, to specifically challenge the reliability and accuracy of the facts in the PSR. That's particularly of importance when it comes to convictions, as Fowler also noted, that the defendant himself is in the best position, not his attorney, because he wasn't the defense attorney from 2022 or 2023, probably would not be aware of the state conviction from 2007, nor necessarily even have access to the records. Nor would the government, and nor would the court. The probation officer certainly had access to some of those records as reflected in the PSR. But in all events, the defendant is in the best position to raise this issue, and he failed to do so. And he can't now try to bootstrap his other objections, which don't directly address that issue. So consequently, in light of the failure of the defendant to properly object, the government's met its burden, and the court under Fowler is permitted to adopt the PSR and under the rules of procedure. Now, the adoption of the unchallenged PSR finding as it relates to that state conviction generally will satisfy the plain error standard under the recent case law that we briefed in our supplemental briefing. Both the Fowler, Hoover, and Cariapa cases all indicate that when parties fail to object to a PSR finding, court adoption of that finding is generally not going to be error. And that's, again, consistent with Rule 32 of the Rules of Criminal Procedure. The way the courts has analyzed that issue has been in a somewhat of a syllogistic way. It said in Fowler and Hoover and Carriapa, all three, that since there was no objection, then the court did not err in adopting that finding. As a threshold analysis, there's not error. And then, but that doesn't necessarily end the analysis for this court, because as Fowler did, it undertook a plain error analysis, which is more retrospective, as plain error should be. And even under that more post hoc retrospective analysis, the record supports the court's finding in this case. There was some discussion with my friend about the indictment and what the indictment said as it relates to cultivation of marijuana. If the court were to look to the indictment in the record, which was filed with Mr. Burns' brief, you'll see that the indictment indisputably shows that there was one count charged of manufacturing marijuana. And it explicitly states this is the correct statute in the state code, and it explicitly states it admits manufacturing, but it also indicates the means by which that offense was committed, which is cultivation of marijuana. And so that's where the PSR finding, and that's where the reference to cultivating marijuana comes from. The court records further show, as reflected in the PSR, that the jury in the case tried and convicted Mr. Wable on that offense of manufacturing marijuana. Now, after that, as the parties have acknowledged, and as the court has recognized already, Judge Benjamin, Judge Agee, I believe specifically, that the record is undeniably confusing in some respects. Counsel's conceded that. Counsel's conceded that it's ambiguous, at least, and unclear in certain respects, especially when it comes to the sentencing orders. And there's some contradictions and counterintuitive findings, to be sure. And so consequently, we're left to speculate as to what happened in the state court proceeding and why some of that occurred. But that speculation in itself, that lack of clarity in itself, precludes any finding of plain error, because it certainly cannot establish that it was clear and obvious. And as the court, and as Judge Agee reflected, with the attempt conviction, insofar as he was convicted or sentenced on attempt, which again, the record in one respect suggests, but is not clear. It's also contradictory because the sentence that he received in the underlying state case was not the lawfully allowed sentence for felony attempt, which could be no more than 1 to 3 years, as opposed to the 1 to 5 year sentence that he was imposed. So in all events, even if this court were to find that there was plain error, and I would suggest that there's no basis to do so in this case, it would have necessarily been harmless error, because the court made very clear that the guideline range was inadequate to address, and this is a quote, to address the seriousness of the offense conduct and Wable's lifelong violent criminal history. The court made a very clear record that the guidelines were insufficient. And even the guideline that would have been higher than what the guideline Wable would now essentially argue for had the state conviction not been counted. So having said that, I'll move on to the second issue with respect to the mitigating argument and the court's addressing that argument. As to that issue, Your Honors, the totality of the court's sentencing rationale clearly demonstrated that the court rejected Mr. Wable's mitigating argument. This court has never held that in every case, irrespective of the circumstances, each mitigating argument must be explicitly addressed. In the Powers case, which is cited in the government's brief, the court makes a really helpful observation in saying that appellate review is not a game of gotcha, where we tally up the number of distinguishable arguments and that a defendant mentions and before the district court, and then comb the sentencing transcript to match up each argument with the court's sentencing rationale. Context matters. And here the context clearly shows that the district court considered and rejected the mitigating arguments. and engaged in a very thorough 355-3A analysis. Now, in his brief, and to some extent as alluded in his opening argument, Mr. Wable, through Mr. Byrne, is relying on the line of cases from Blue, and understandably so. Blue is a seminal decision when it comes to addressing non-frivolous arguments by the defense. The Blue court found, importantly, though, Blue is distinguishable, and in Blue, the reliance on Blue in those line of cases are misplaced, because first of all, in Blue, the court found that the district court did not explain the 355-3A factors or their principles, or how their principles shaped the sentencing decision. Here, by contrast, there was a fulsome analysis of the relevant sentencing factors, focusing on the circumstances of the offense, which were created, as the court found, an extraordinarily dangerous situation for the probation officers, and also involved tampering with witnesses and suborning perjury before the district court. The court also paid much attention to the defendant's lengthy criminal history, which include significant violent crimes and unscored violent crimes, including a murder. The court spoke to the defendant's recidivism in that respect, and also lack of remorse. So, in contrast, again, back to Blue, in Blue, the lower court record provided insufficient context to provide any meaningful appellate review. And if the court, and out of interest, because Blue is such a significant case, I look back at the joint appendix of that case, and the sentencing rationale in Blue and the transcript, it literally encompasses a paragraph. It's a paragraph long. Here, the district court's rationale encompassed 6 pages of the transcript. And on a similar token, the cases that are cited by Mr. Byrne in his opening brief for this proposition that the district court must understandably respond to non-frivolous arguments by the defendant for mitigation and variance, all those cases, Ross, Lewis, Torres, Reyes, they all had this similar cursory explanation and rationales that were provided, which the court found insufficient, and also indicated that they provided no basis for meaningful appellate review. Here, though, we don't have that. The district court necessarily rejected the argument of alleged pretrial abuse as incredible and unsupported. It's important to remember the context here. You have a defendant who committed a fraud upon the court, as the district court explicitly found with respect to his suborning of perjury. As Judge Agee noted, the district court repeatedly acknowledged that he read the defendant's pro se memo and filings. And the district court also unequivocally stated that the argument for downward variance lacked evidentiary support. And in fact, it did lack evidentiary support, even with respect to this singular claim as to pretrial abuse. It was a mere allegation. There was no corroboration of it. There was a claim in his pro se memorandum that he had submitted some kind of a complaint to the U.S. Marshals or to the regional jail, but that complaint was never provided as part of the record. And we're also left to speculate about the possibility that maybe if in fact it did happen that a regional jail correctional officer sprayed him with pepper spray or something like it, it could have been provoked. We don't know because there's no evidence of that. The court otherwise, again, had no reason to take the defendant's argument seriously because of his deception and blame shifting in the case and also in his allocution. The court explicitly found that Wable attempted to commit a fraud on the court and on the justice system. And the court also dismissively noted that Wable portrayed himself as a lifetime of being a victim, which necessarily would have encompassed this jail abuse claim as well. So, having said all that, Your Honors, the district court engaged in a thorough 355-3A analysis. It made a direct and contextual both rejection of any mitigating arguments that the defendant offered, and also provide an ample record for this court to conduct a meaningful appellate review. And for those reasons, it could not have committed any reasonable or procedural error And based on what I indicated earlier, any such error, to the extent that it's even possible, would be harmless. I'll be happy to answer the other questions that your honors have. Otherwise, I'll rest of my brief.
All right. Thank you, Mr. Coger. Mr. Byrne, you get the last word. You have some rebuttal time.
Thank you, Your Honors. Very briefly, I will start where Mr. Coger ended, which is the nature of Mr. Wable's claim regarding the abuse at the jail. He called it incredible and unsupported. But Mr. Wable made that claim prior to sentencing. The government never tried to disprove it. The government never produced those U.S. Marshals that he talked to, who could have said no. He never mentioned this. It is unfortunately a fact of life that the West Virginia regional jail system is a mess and frequently has issues with mistreatment of inmates. My office sometimes represents people who are accused of federal crimes because of that. So the idea that Mr. Wable might have been abused during trial is not so out of the realm of possibility that it can just be dismissed out of hand. But we don't even know whether the district court dismissed it out of hand because the district court never addressed it. And it's important to keep in mind.
Well, was there any proof in the record other than Mr. Wobble's ipsa dixit here? I mean, he didn't say, look, Judge, here's a bruise I got. Here's a copy of a complaint I made. Here's a letter from another inmate to back me up. I mean, this is just his story. I mean, there's nothing to verify it. I mean, why would the district court be under an obligation to undertake some sort of independent investigation if that's all you got?
I think the district court was under an obligation to do an independent investigation, but if the district court wants to reject it on that basis, it should say so. And we don't know that the district court rejected it on that basis. The district court may have rejected it on the basis that this is not a legitimate basis for reducing a sentence under 3553A. And as we showed in our brief, there are many courts that have done so. That would be an error that would require reversal. So I don't think the fact that the district court gave a thorough explanation for the reasons it imposed the sentence it did necessarily precludes the argument that there were other things the district court should have addressed because they might have made a difference. The other thing I just wanted to point out, given my limited time, contrasting this case to Fowler and the other cases that Mr. Coger talked about, there was an objection here. It was pro se. It was not necessarily on point, but there is scads of case law out there about how pro se pleadings are entitled to sort of a benefit of the doubt, to not be construed as strictly as counseled pleadings. And again, I think that should have set the court onto trying to get to the bottom line of that 2007 conviction. If there are no further questions, I will just rest on my briefs and ask that this court vacate Mr. Wable's sentence and remand for resentencing.
All right. Thank you, Mr. Byrne. I want to thank both counsel for an excellent argument, and we'll take it under advisement. Obviously, we can't come out of the screen and greet you like we would in Richmond, so we look forward to having you all back at some other time. So with that, I'll ask the clerk to adjourn court sine die.
This honorable court stands adjourned, sine die. God save the United States and this honorable court. All right. Mr. Kogar, you can disconnect. Thank you. Judge Age, it looks like I lost. Oh, she's still here. I'm going to put you all in a breakout room so you can conference. So whenever you're ready, just go into that breakout room so you can conference in private.
You're going to send us a link to do that, right?
Yes, it's going to be in the Zoom, and you should just have to click to go into the breakout room. Oops, hold on one second.
we go.